Good morning, everyone. My name is Tom Bickel. I'm a current senior and pre-law student here at Brown. And today, on behalf of the Brown Undergraduate Law Review, I have the privilege of being joined by Michael Lewis Levy as part of our alumni interview program. Professor Levy, as I will refer to him today, was a graduate of the class in 1966, during which 4 years he was a member of the men's swim and dive team and concentrated in mathematics. Shortly after Brown, Professor Levy went on to earn a degree from Penn Law, after which he spent the next 50 years practicing law. For 40 of those years, he served as a federal prosecutor, as he spent 37 years with DOJ. More recently, however, teaching has been a hobby for Mr. Levy, as he's known for leading a Penn Law seminar on the topic of cybercrime. I could go on, but without any further ado, Professor Levy, thanks for being here.
Thank you. Thank you for having me.
So right off the bat, given your expertise and experience with privacy law, can you remind us what the Fourth Amendment actually says and what some of the primary motivations might have been?
Sure. So the words of the Fourth Amendment are
the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized.
Fourth Amendment has two clauses. The first is the right to be secure against unreasonable searches and seizures. And the second describes what a warrant for either searching or seizing, that is arresting or seizing property, has to contain. The Supreme Court has interpreted the whole Fourth Amendment to say that a search is unreasonable or presumptively unreasonable if it's not done with a search warrant. And then over the years, it's created exceptions to the search warrant requirement for things like consent. So if somebody agrees you can search, then you don't need a warrant for that. Search incident to arrest, where you can search the person in the immediate area around them so they don't destroy evidence or don't have a weapon. Plain view, if you're conducting a search and you suddenly come across something that you realize is contraband, for example, the police can seize that. Exigent circumstances, some kind of an emergency that says, I've got to seize this now, it's going to be destroyed or the person is going to run away. And so you can do without a warrant. And the last one, which is becoming a big one now, is the border search that is coming into the United States or going out of the United States. The government has the right to search without a warrant.
Right, so that's like the Mexico border type stuff.
Yeah, or anytime you fly into the United States from outside, you will come in, you will pass an immigration station that's going to check your passport, ask you some questions, and the next place you're going to go is you'll pick up your luggage, and on your way out, there is a Customs and Border Protection agent who has the right to search you. Most of the time, they just take your declaration and you go through, but they have the right to stop you, open up your bag, and see what you have inside it.
And do they have the right to search everything in your car, for example, if you're crossing the border?
Yes.
So there's nothing that's off limits.
Nothing off limits.
It just makes me curious, because I know that there's so many instances where people get away with contraband there. It makes me think.
Oh, yeah, I mean, it doesn't mean they search every car.
Right.
It's sort of a, they have profiles, they do random stuff. It's basically to protect the country against bad things coming in. Mostly now today it's drugs, but
yeah, exactly.
So the idea is just to seize things before they get in. It's originally interesting. It's based originally on the customs power of the United States, because the only tax the United States had at its origin was customs duties.
And this is just sort of a tangent, but I just thought it was interesting. Isn't it true that I can't remember if this actually happened in the OJ case, but wasn't some sort of murder, some sort of evidence for murder found without getting a search warrant in that case? In which case it was put aside and not able to be used.
I just don't remember. It's very well possible. Yeah.
Well, that happens sort of like, I mean, I shouldn't say it happens all the time, but it actually happens in real life, right? Where there's investigators don't properly apply for the search warrant. They end up finding something that would be totally evidence for the crime that's being investigated, and then ends up, not being qualified for use in court, right?
I'm sure the one exception I didn't mention was the automobile exception, which doesn't require a warrant because the car is mobile. And my guess is we probably have more stops of cars and then searches of cars either based on suspicion or based on consent. Then we have more searches executed with warrants today.
Right. I was going to ask about that. That's pretty much solely reliant on the idea of probable cause, right? For those car searches without a real warrant, and from law enforcement at least, right?
Well, I mean, first you need probable cause to search the car, but what frequently happens, and it's interesting because this morning's Philadelphia Inquirer reports on a city council bill that just passed, limiting police stops, not allowing police to stop for things like broken taillights or expired registration stickers, requiring them to mail a summons, because as it turns out in Philadelphia, turns out to be a reason for stopping a car when you really are stopping the car for some other reason. And now you have this pretext for a stop. And the Supreme Court has held that pretextual stops are okay, as long as there is an articulable basis for making the stop. The police are allowed to do it, even if that isn't their motive. In other words, you focus on the facts, not on their brains. The statistics in Philadelphia is that our African-American population gets stopped at a much higher rate than the white population.
Right. And forgive me if this is a stupid question, but what exactly are they trying to prevent from happening with laws like that? They're trying to prevent just bias in the
Yes.
probable cause. That's
Yeah. I mean, what ends up happening, I don't have the exact numbers in front of me, but something like more than 75% of the car stops in Philadelphia are of African Americans, and they only represent 43% of the population. And they result in about 8% where something is found. So you've got a lot of African American people driving cars in Philadelphia, getting stopped, having their cars searched, and then going on. It's that, that slogan of driving while black.
Right. I guess on the other side of that, you wonder, if you make it more difficult for law enforcement to technically do their job, right?
Yep.
That's certainly within the purview of their job, is to, allege probable cause and execute it. I can understand why law enforcement would be maybe frustrated with those sorts of laws.
Right. But everything we're going to talk about today is a balance between our right to be left alone, right of privacy, and the state's right to enforce laws.
Right.
Keep us secure.
Right. Exactly.
It goes back to the beginning of the Republic.
Right. Talk a little bit more about what the motivations behind the Fourth Amendment were.
Sure. It's interesting because the Fourth Amendment, as you could see there, was it talks about persons, houses, papers, and effects. And the original Fourth Amendment was never thought of as a privacy right. It's a property right. It's and a personal security right. So that property is really important to the founders. You see it in the Fourth Amendment. The Fifth Amendment has a due process clause that prohibits taking a property without due process. There's the takings clause that says if there's going to be a taking of property, it has to be with just compensation. And it dealt with seizures of the person, right, as arresting people, searches of property, back then houses, and seizures of things. And the experience in the colonial times with the enforcement of the British taxes was the searching of houses for records that people hadn't been paying the customs duties, and also beginning to look for the correspondence that was being sent up and down the eastern seaboard, protesting all the things that the Crown was doing. So it's changed over the years, and I would say it starts with the invention of the telephone. As a communications tool, we had the telegraph before the telephone, but you don't have a telegraph key in your house. And while the telephone was introduced, I think in 1876 at the Centennial Exhibition, people began to use them. I've seen a picture of the Manhattan telephone directory from about 1895. It's probably about that thick. If they printed one today, it's probably this thick. But people began to use the telephone. So you combine the telephone with prohibition, and the telephone became a tool for bootleggers to run their business. Mm-hmm. And in the 1920s, there was a case in 1928, the case of Olmsted, versus United States. It was a large bootlegging operation in Seattle, Washington. And the agents enforcing the Volstead Act, the Prohibition Act, conducted a wiretap. The way they did it is they went to the telephone lines outside the house. They inserted the wires into the telephone line, ran lines back to where they were, and listened to the conversations.
Wow.
Literally, it was a physical placing of the wire into the telephone line.
It was literally tapping the wire.
That's why the name comes of wiretapping, is they literally tapped the wire. Case goes all the way up to Supreme Court with Olmstead arguing this is a violation of his rights under the Fourth Amendment. This is an unreasonable search and seizure. And the Supreme Court writes an opinion. It was written by Chief Justice Taft, who had been the president, saying, no, it's not, for two reasons. First, there is no trespass. We need it. The Fourth Amendment protects property, and there was no trespass into your property. The second ground was words are not persons, houses, papers, or effects. And so on either ground, the Fourth Amendment doesn't cover this. Taft went on to say, Congress can regulate this, but the Fourth Amendment does not. Justice Brandeis wrote a dissent that proved to be very prescient, and he objected to this, and using kind of language that's a little bit flowery and rhetorical, but it does get his point across. Ways may someday be developed by which government, without removing papers from secret drawers, can reproduce them in court, and in which it will be enabled to expose a jury to the most intimate occurrences of the home. And the other line that's kind of famous was, discovery and invention have made it possible for the government by means more effective than stretching upon the rack to obtain disclosure in court of what is whispered in the closet. Brandeis' opinion is, to my mind, at least as far as I can tell, the first time somebody used the word privacy when talking about what the Fourth Amendment was about. So we move along that way. The telephone obviously gets much more common. By the 1950s, just about everybody had one. It was probably 85 to 90% of the homes in the United States had them. And the ability to bug and to wiretap became more readily available. And in 1967, the Supreme Court dealt with the problem of basically overruling Olmstead in a case called Katz versus United States. And that's a case where we moved away from the property rationale of the Fourth Amendment to one of privacy. It was Justice Harlan, in his concurring opinion, that used the term a reasonable expectation of privacy. And the test that he propounded, that the court adopted as the law a few years later, was first that a person has to have exhibited an actual expectation of privacy, a subjective expectation, and second, that expectation has to be one that is reasonable.
What's an example of an expectation? I'm just curious.
If you're in your home and you close the curtains, you have an expectation of privacy in your house. And it's interesting because both Justice Harlan and the majority said something along the lines of, what a person knowingly exposes to the public, even in his own home or office, is not a subject of Fourth Amendment protection.
It's interesting how it's almost like they're doubting the credibility of your claim, right? They're doubting, are you genuinely interested in
the first thing is, do you demonstrate an expectation of privacy? You can do that in a number of ways. Let me take the Katz case as an example. Katz was a gambler, and Katz did his operation by going to a phone booth. I put a picture up here because they were common when I was growing up. I'm not sure that every undergraduate today has seen one.
I don't know about that.
Yeah, so this is in New York, and they were on most street corners and in buildings, in bars and restaurants. If you grew up watching Superman, this is where Superman or Clark Kent changed into Superman. So what happened was the FBI wanted to intercept his conversations, so they put a bugging device on top of the phone booth and intercepted his conversations. And the Supreme Court held that he had a reasonable expectation against it being overheard when he was in the phone booth. No, it wasn't his house, but it was a space that temporarily he had demonstrated an expectation of privacy, and the phone booth was in such common use that the court felt that was his expectation was reasonable. The case is interesting because it really highlights some of the debates about interpretation of the Constitution. Justice Black was a Franklin Roosevelt appointee, and he was a liberal. He was also a textualist. He dissented. His dissent was, words are not persons, houses, papers, or effects. The Fourth Amendment has nothing to do with this.
So that's, like you said, like a strict constructionist approach.
Yep. You know, and I mean, he went to the words and said the words don't apply. Katz still did, the Katz and the cases that followed still applied a property-based concept of privacy in that they applied it to a space that a person was in. Could be a hotel room, could be an apartment. If you're visiting a friend and you're staying overnight, you would have an expectation of privacy there. And Katz had his expectation of privacy during the time he was in the phone booth. Development of the computer and the internet have kind of changed our perceptions, and the law is beginning to struggle with that. We're moving our lives onto the internet, and some things translate easily. So take email. Does the Fourth Amendment apply to email? Well, email is like an old-fashioned letter. It seems like a paper and effect, and most courts that have dealt with the problem have held that the Fourth Amendment protects the email that you send. Other things are not so simple. Couple of factors playing here. The Computers Act, computerized devices are kind of like a force multiplier for law enforcement, and I'll illustrate that in a second. And there's the possibility of Big Brother type surveillance. So in Jones versus the United States, which is a 2012 Supreme Court case, law enforcement officers put a tracking device on Jones's car. Didn't enter the car. It had a magnet. They could just walk up to the bumper of the car, stick it on the car, and then follow him. Jones claimed this violated a reasonable expectation of privacy. Justice Scalia wrote an opinion avoiding the problem by bringing back to life an old concept of a trespass. He said by putting the device on the car, they trespassed against his car, and they did it to gather information. So that was a search. Justice Sotomayor and Justice
one of the other liberal justices.
Yeah, no, it's Third Circuit and from New Jersey. It'll come to me in a second. Alioto, Justice Alioto concurred in the result. Sotomayor joined the majority opinion, making it a majority, but they said that this kind of tracking violated a reasonable expectation of privacy. So what troubled Justice Alito was that what I call the force multiplier effect. Before we had all these devices, to track somebody would take 10, 12 agents to do that. You needed multiple cars to follow them. You needed cars on blocks on either side, so if the person turned, you could pick them up. There were practical limitations on tailing somebody that acted as a limitation on law enforcement. When you have a tracking device, you can put it on a car and an agent sits in an office and can watch on a television screen with a GPS map up there. If he can do one, he probably can track 5 or 6 cars. So we flipped from 10 to 12 agents to track 1 car to 1 agent to track 5 cars. And suddenly it becomes a whole lot easier to start following people around. And Justice Alito was troubled by that. The Carpenter case, which is 2018, which is cell site location information case. Here's a case where they had multiple bank robberies. And when they came to suspect Carpenter, they went to the phone company with a court order to get the cell site location information. Phone companies, your cell phone only works because the phone company knows where you are. You're constantly in communication with the towers. And anytime you make a call, the phone company records that as to what tower you were on and how long you were on. So the government got this information, and 8 to 10 robberies. Carpenter just happened to be in the vicinity of those robberies in most of the cases. And when I say vicinity, this does not put him at the bank. It puts him in the general neighborhood. It can be an 8 to 10 block radius around the bank. The court was troubled by this, even though it didn't track him with pinpoint tracking. And what they said was learning the whole of a person's movements is an unreasonable search. And since the government got a court order, and I'll talk about those orders in a minute, but not a search warrant, they said that the government couldn't use it. So think about what we have here. When the government got cell site location information from the telephone company, did it seize Carpenter? I think the answer is pretty clearly, in our view of seizure, no. And when they got the papers, the records, whose papers and effects were they? Carpenter didn't create them. Carpenter didn't store them, but they were his papers and effects. And the dissents of Kennedy, Thomas, and Gorsuch focus on this. Jones and Carpenter reflect a court really disturbed by the creepiness of long-term tracking. And Carpenter also reflects a concern that this data is collected by the phone company and saved. And then the government can come back and search it. So those are the concerns we have here, but we are really far from the words of the Fourth Amendment now. Is the Fourth Amendment whatever 5 justices say it is? Justice Gorsuch is troubled by this, looking for a property theory, that somehow we have a property right in.
Right, because he's a Lockean. He's a Lockean. Yeah. Exactly. So he's got all sorts of sophisticated views about property.
Yeah. So, if you look at this, if you're a textualist, these are not the person's records and they're not the person's papers or effects. If you're an originalist, I recommend you read the debate between Scalia and Alito, because they're talking about what happened at the time of the Constitution if a constable wanted to follow somebody in a coach and somehow secreted himself into the coach, which is the equivalent of the tracking device. And there's this debate back and forth with some funny lines, one of which include a line about something that would take either a very large coach or a very small constable to do that. So if you're an originalist, you're going to kind of focus on what was going on there. If you believe in a living constitution, I think you'll come up with a solution somehow. So the framework you use for constitutional interpretation may influence how you come out here.
Are you implying that the sort of living constitutionalism has played a much greater role in the interpretation of privacy, given that there's sort of, like you've explained, there's this departure?
It plays some role certainly in the Katz decision. Even Justice Harlan, who was a conservative, recognized that things had changed. He was a guy in a phone booth. I mean, original rules were was Olmstead. Words are not persons, houses, papers, and effects. And he wasn't in his home. And Justice Harlan said, no, this is wrong. We need to construe the Constitution to keep up with these kinds of invasions, right. and was clearly focusing on privacy. For myself, I'm not a strict originalist or a textualist, but I think words are important. And the Fourth Amendment can't mean something just because we want it to. I'm a big fan of the necessary and proper clause of the Constitution, which is Article 1, Section 8, Clause 18. Congress shall have the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. And right after the Katz decision, the bugging case, Congress passed a Wiretap Act. Katz was in 1967. By the end of 1968, we had a Wiretap law. The Supreme Court has not decided a case involving bugging or wiretapping on constitutional grounds since then. The statute covered it. We could have, Congress could regulate a lot of these areas. Now, I know how dysfunctional Congress is today.
Yeah, why don't they?
Yeah,
I think they choose not to.
I mean, part of it is, the last 20 years, going on 30 years, we've seen major dysfunction in Congress. It's not a collaborative body anymore. I mean, not that they didn't argue and fight, but the idea of, arguing on the Senate floor and then going and having dinner or a drink together is just foreign today. I think there's some hope here because the this is an issue, privacy is an issue that doesn't divide on Republicans and Democrats. I jokingly refer to it divides by libertarians and authoritarians. You've got libertarians, like Rand Paul and Ron Wyden in either party. And you've got what I call authoritarians, Dianne Feinstein and Richard Burr. And so I think they'll figure out a way. I mean, the splits are strong, but it's not a partisan split.
Right, it's not a party line split. I was going to briefly ask you just about that. I like that distinction you made about libertarian versus authoritarian. Yeah. I was going to actually ask, so just personally, I'd like to read a lot about religious liberty cases. And one of the things that you said sort of reminded me of like the sort of way that the court has devised all these different tests, obviously, to sort through religious liberty cases. So it's like when you're talking about how there's this test to, if there's a reasonable expectation of privacy, right? That I think that's a part of that libertarian versus authoritarian debate, in the same way that religious liberty tests, one of them is this a sincerely held religious belief? You know what I mean? So I think I view those as like parallels in a sense of like, there's this sort of like cynicism from the court saying, well, are you here just to try to win your case? Or, is this a sincere religious belief? Is this a sincere expectation of privacy? Or did you just do something stupid and you're here because you want to win, you want a favorable outcome? You know what I mean? And I just think it's interesting how they develop those very precise and effective tests sometimes that actually do pretty accurately arrive at try to sort through whether or not the person's just playing games. Right. I mean?
And the problem, the reasonable expectation of privacy test doesn't work anymore. I mean, think about Carpenter and think about Jones. These are two people driving around in public. When the Katz opinion came down, they made clear that what you expose to the public, even if it's inside your house, if you leave the curtains open, is not protected by the Fourth Amendment. Well, driving your car around in public is the quintessential not demonstrating a subjective expectation of privacy. So that test just doesn't work anymore.
Right.
I don't know what the test will be. I mean, one of the reasons I've done a lot of thinking about this and is that reasonable expectation of privacy, which is what I lived with, I guess the whole time I was practicing law. It was decided before I graduated law school. But it takes us away from the words of the Fourth Amendment. And while it sounds good, and I think as a matter of policy, it worked pretty well for a long time, but now we have to come up with a new test, and it's going to be 5 justices of the Supreme Court deciding what it is. And since we're moving on to the internet, and most of them are older and don't have any real technical background, I'm not sure they're the best people to decide what's reasonable. And today we really don't have any shared values in this area. We do with property, but the difference between your generation and mine about what we do online is just radical.
I guess what you're sort of suggesting there is that maybe the younger generation is probably more okay with throwing things online and kind of abdicating their privacy, right?
Right. And Justice Alito points this out, and one of the things he points out is the use of the look at things like Waze. And I use it, I'm in my 70s, but that means that Google is tracking me all the time. It's something that I'm okay with because I want to get good directions and avoid traffic. Yeah. So I make that trade-off myself. I've got a smart thermostat at home that uses my wife's and my cell phone to determine when we're not here.
Right.
That means that Nest, which is Google, knows where we are.
Exactly. I mean, yeah, Google's the most powerful company on the planet, yeah. Right? And they pretty much have a hand in every digital, every digital product. They have a hand in it. So I guess we can just speculate on this because this isn't something that can really be backed up by the sort of case knowledge that you have. How would you describe the quality of privacy that Americans experience today, given the obsession with modern technology that we have?
I guess the first question is privacy from whom? If you have accounts on Facebook or TikTok, nobody's forcing you to upload your data. You're choosing to do it. I'll ask the audience, did you read the terms of service when you signed up? If you're like everybody else, the answer is no.
Exactly.
You know what they can do with your data. And it's not just what you upload. They track you. Do you know that? Do you opt out of tracking? Down at the bottom of your screen regularly, there'll be the thing about cookies. Are you reading those options and opting out of the tracking ones? Do you realize that they sell your data and sell the ability to show advertising to you?
Yep.
The Fourth Amendment's a limitation on the government. The United States is different from Europe. The European General Data Protection Regulation, the GDPR, gives individuals a right of privacy against the world. The Fourth Amendment gives us a right of privacy against the government. Between the Constitution and a statute called the Stored Communications Act that was passed in 1986, there are a set of rules that govern what the government has to do to get data from these providers. And it prohibits them from giving things to the government outside the rules of the Act. And except for what I'll refer to as basic subscriber information, your name, they have your address, how you pay for the service. With telephone companies, you can get the recent dial numbers with service providers with IP addresses, internet protocol addresses. You get the most recent logins. Other than that, the government needs to go to a court and get a court order. For content like emails and messages, it needs a search warrant covered by the Fourth Amendment.
Even if you're on somebody else's, I could be wrong, but like, for example, if I'm sending emails on Brown server, on a brown.edu email, right, since they own the server, don't they have access to my emails?
They do, and Brown can do things with them,
right,
but the government won't get them without a search warrant.
So the government won't get them. So Brown has them, but
Brown has them. Brown can read them. And being a university, my guess is they don't.
Right.
But yeah, if you're working for Boeing on some secret project, they can read your emails, and they may well do that.
Right.
For all other records, detailed records, the court order requires that the government show specific facts why the information it's trying to get is relevant to an ongoing criminal investigation. This is really very close to a search warrant standard. I think it is for practical reasons as well as legal reasons, not worth going into today. The difference is that law doesn't require that it be under oath or affirmation. And from a constitutional point of view, that's significant. So I think we have less privacy in our online lives with respect to the providers, but probably pretty good privacy with respect to the government.
It's a really interesting, nuanced answer, because I was going to bring up the example of TikTok, which, I'm sure you're not the most familiar with TikTok. It has nothing to do with your interests, but I know at least that just based on following the news over the pandemic, things like that TikTok, so I think it's like a good example of the sort of distinction you're bringing up between, well, privacy from who? Is it from the government, or is it from just the rest of the world in general? So allegedly, I don't have facts to prove it, but allegedly TikTok is known for taking the copy and paste stuff on your phone. It has access to just any sort of thing that's stored in your copy and paste. There's a word for it, I can't remember, but it's not exclusive to TikTok. So it's anything you're storing in that function of your phone.
Oh, really?
Copy and paste.
The equivalent of a clipport on a phone.
That's it, exactly. Yeah. Clipboard. That's the word I was looking for. So that apparently they're able to use that data among all sorts of sort of other insidious things. And like you said, it's not that the government's spying on us, our government, but apparently that goes back to web developers in China, and they learn more about what American interests are, what are consumer preferences, obviously, right? So they essentially conduct, I guess, I don't want to actually call it this, but it's almost like they're getting away with market research just by using this app to like insidiously spy on us. You know what I mean?
There is one difference with respect to the government that I think is significant. All this stuff that we put online stays there for a long time. That was the concern in Carpenter, that the cell site location records were there. So, 6 months, a year later, when the government starts investigating a crime, those cell site records are still there. And so the government needs a search warrant to get them, but the evidence is there. And this is kind of a lesson for your generation. When I was growing up, when we did stupid things, nobody was recording it. Kids make stupid mistakes today, and somebody is recording it on a phone because you can, and that record's around for a long time. So conduct yourselves accordingly.
So maybe don't put things online. I don't know.
Yeah, but your friends may take photographs of you and then put them up on Facebook when you're at a party and you're drinking. Employers now go back and look for you when they're considering hiring you, and pictures of you, completely blitzed at a party, when you were a sophomore in college.
And it's relatively easy to do, right?
Oh, yeah.
That sort of goes along with the whole, I guess, so if that's one invasion of privacy, I mean, like you've given a nuanced answer to it though. Like the first thing you said is well, have people actually agreed to the terms of services, or have they even read it? I mean, well, really, you're saying have they read it? Of course they agreed to it. And the answer is almost 99.9% of times, of course they haven't read it. They don't care. So more so than anything, if I understand you correctly, it's really that, especially the younger generation is sort of just okay with abdicating their privacy. They might not know that they're abdicating their privacy to, web developers in China or you name it, but they kind of couldn't care less, right?
Right. I mean, the great saying about the internet is, if the service is free, then you're the product.
Huh. That's a good transition to, if that's potential privacy invasion from the private sector, right? Now I guess I'll officially transition to the topic of what is it about the Patriot Act that is so egregious, something that, people have been talking about the potential violations of the Patriot Act ever since it was passed, yet it was passed by a relatively bipartisan Congress. And since then, it hasn't been struck down by the Supreme Court, at least to my knowledge. So at least, from someone that knows very little about this, just from a purely observational standpoint, it's difficult to understand why something that people complain about so often is still upheld as legitimate law.
I guess, so the first question is, what part of the Patriot Act are people referring to? Have they actually read it? Lesson one for those of you who are going to law school, be wary of slogans, learn the facts, analyze the problem. The Patriot Act has many, many parts. Some of it was updating old laws that nobody would object to. I think the biggest objection is probably to the amendments to the Foreign Intelligence Surveillance Act, or FISA. FISA was passed in 1978 to deal with national security surveillance of American citizens that was exposed during the Watergate investigations. It turned out that they were conducting warrantless wiretapping against American citizens for all kinds of reasons. Probably started in the Second World War, looking for spies from Nazi Germany and Japan and Italy. And of course, nobody objected then. And then as we got into the 1950s, it started being against communists and the John Birch Society. And as the civil rights movement grew, and then the anti-war movement grew, there was more wiretapping and bugging of those people. And suddenly, people began to object to, when they heard about it. And this sort of came to a head in Watergate when we started learning about the number of things that were being bugged. Anybody interested? I actually have about a 15-page excerpt from the Church Committee report that summarizes some of their findings. It's pretty disturbing. I give it to my class to read. So FISA set forth a set of rules for how the government can conduct surveillance of agents of foreign powers. A number of courts had ruled before FISA that spying on foreigners, spying on a foreign power, was an inherent power of the president under Article 2. The courts had nothing to do with it. FISA said, no, you have to go to a court. And I think there's an interesting constitutional question whether that part of FISA is constitutional or not. Does it impinge on the powers of the president? Keep in mind, FISA was passed in 1978. The president's power was probably at its nadir at that point.
So like a separation of powers issue there.
Yeah. But that was the rule. And courts interpret, the statute said that the purpose of the wiretap had to be for foreign intelligence gathering. And the courts interpreted that to mean the primary purpose had to be for that. And when the primary purpose switched to law enforcement gathering, you had to use the Wiretap Act. You could no longer use FISA. FISA changed the standard to a significant purpose. that still has to be a purpose, but it could be both foreign intelligence and law enforcement. And espionage is a good example, where you may be gathering evidence against a foreign spy, but we may choose to prosecute him or her here in the United States. To get an order under FISA, and I was not in a national security division, so I never got one. Got wiretaps, but I never got one of these. You've got to identify and describe the person who's the target of surveillance. You need a statement that justifies belief that the target is an agent of a foreign power. And for a US person, that is a citizen or a green card holder, it can't be based solely on First Amendment activities. The facilities you're going to intercept the phone, the computer, will be used by the agent of a foreign power. You have to come up with minimization procedures to get rid of stuff that you collect that has nothing to do with it, so that it doesn't get disseminated. A detailed description of the information you're seeking and the type of communication activity that's subject to surveillance. So if you're doing a cell phone, you've got to justify not only the phone conversations, but also text messages, each of them independently. You need a certification that a significant purpose is to obtain foreign intelligence, and that certification has to be made by a high-ranking official, the Assistant to the President for National Security Affairs, Director of National Intelligence, an Assistant AG for the National Security Division, or the Director or Deputy Director of the FBI. That's a lot of high-ranking people that have to get involved. And it's going to require a large number of people to lie that this is a national security case when it's really only a regular criminal case.
There's pretty high thresholds, essentially.
Yeah. The standards for getting a FISA tap and a Title 18 wiretap are similar, they're not the same. And then there are the practical checks, in addition to, am I going to go to the director of the FBI with this and say, we ought to do it? There is a split in the government house between intelligence and law enforcement. Intelligence agents want to gather information, and they are afraid that if we disclose what we have, we're going to disclose sources and methods, either where we got the information from or how we're collecting it. Maybe they know we're on a wiretap, but they can tell from the disclosure whose phone we were on. So intelligence agents have a big pull never to disclose, which means never to prosecute. Law enforcement agents, hey, let's arrest this guy, let's put him in jail.
Right.
If you're a law enforcement agent and you're building a criminal case, the last thing you need is somebody from the CIA telling you, no, we have objections to this, and having to go through the CIA chain of command. When you finally get to, assuming you get to charging somebody with this information, you have to work with the Classified Information Procedures Act, which is a whole set of complicated rules to deal with how we disclose this information in court. FISA is not something I would choose unless it was really necessary for a case. Now, FISA is not perfect. We've had 2 Inspector General reports in the last year and a half that show real sloppiness on the part of the FBI. I think part of that is the fact that a FISA tap is not likely to be used in court can make agents sloppy. If you're an agent getting a search warrant, you're well aware, or a wiretap, you're well aware there's likely to be a motion to suppress. You're going to be called as a witness. You're going to be cross-examined about what you did and how you did it. That tends to keep people on the straight and narrow. The other problem with FISA is FISA court doesn't generally publish its opinions. We get no discussion among lawyers about the development of the law of professors. We don't have law review articles critiquing a decision.
So I'm assuming that's obviously completely intentional that they do that.
Oh yeah, now they're beginning to unseal more. It takes time because they've got to redact all the classified stuff.
What is the express purpose behind not having?
Not to leak national security information. So they're now redacting opinions so that the reasoning can come out, even if we don't see, a lot of the facts behind it. The value of judges writing opinions is the transparency, the fact that we can critique it. The law gets better because there's debate back and forth over issues.
Other thing about that is just that I read, I guess I'm just trying to gauge your reaction to this based off of what you just told us, is the New York Times described the Patriot Act in the following way. It said that the Patriot Act it effectively allows law enforcement and investigators to stop acts or potential acts of terrorism by any means necessary. Is that an exaggeration? That
Yes.
to me that looks
Any
like an exaggeration.
Yeah, any means necessary means you see the guy on the street and you shoot to kill. You act like 007.
Right.
No, it's not by any means necessary. It's a set of legal rules for what law enforcement can do to gather information for the purpose of either dealing with spies or preventing a terrorist attack.
Right. So that is just that is a little dramatic.
Just yeah, I mean, you remember I talked about the Brandeis opinion having rhetoric. I mean, rhetoric is part of the political debate. But if you're going to be a lawyer, stop and think critically about it. What's really going on here?
Exactly. And in that way, are you sort of implying that maybe the people that are so outraged by the Patriot Act might not have a great case for that?
There are things, as I said, there are things wrong with the Patriot Act, things that can be improved. The Patriot Act's been amended, FISA in particular, and parts of the Patriot Act have been amended a number of times since 2001 as things came out that people found troubling. And Congress has changed it over the years to deal with those problems. I mean, it is
right.
the necessary and proper clause at work.
Right.
We've got a statute, it's got problems, let's fix them.
Right. It's of course been a work in progress, and it's, if I'm gauging you correctly, as it currently sits as law, you don't see it as an egregious violation of privacy. You see it as more of a necessary thing.
Yeah, with the understanding that I had in my 37 years with the Department of Justice, I had one experience with FISA, and that was it. So I haven't worked with it. I don't know the statute.
Perhaps if you worked with it more, you might have a strong.
I might have some things that bother me. Yeah, no question.
Right. The next thing we wanted to ask you about was the U.S. versus Jacobsen holding, which I'm sure you're very familiar with.
Sure.
I'll just briefly introduce that. That's a 1984 case, Supreme Court case, in which the court held that warrantless government search may be permissible under the private search doctrine, only if the search does not exceed the scope of an antecedent private search, such that government learns, quote, nothing that had not been previously learned during the private search. So the reason why I introduced this 1984 holding is because just recently, less than a month ago, the U.S. Court of Appeals for the Ninth Circuit has issued an opinion in a case called U.S. versus Wilson that essentially is combating the exact same issues of this prior Jacobsen case, and now there's a developing circuit split between the 9th and I believe the 5th. There's a developing circuit split among the circuit courts on this issue. So if you could talk about that a little bit.
Sure. Very quickly, Jacobsen was a package sent by FedEx, if I remember right. A package broke open, FedEx looks inside, they see plastic bags with a white powder, they pull them out, they look at them, they call DEA. DEA comes in, pulls out the plastic bags with the white powder, and does a field test and find out it's drugs. And the Supreme Court says, as to pulling the plastic bags out of the box, the government didn't do anything more than the private search had done. The expectation of privacy had already been violated when FedEx opened the package, and the government didn't learn anything more than what FedEx had learned. The field test went beyond that, but the court was relying on some cases involving dog sniffs, where they had already held that if you turn a dog loose against luggage in an airport or against a car, and the dog reacts to the presence of drugs, that's not an unconstitutional search, because nobody has a reasonable expectation of privacy in the possession of contraband. So the dog was a yes/no test. The dog didn't say, "Here, what's in the trunk?" It just says, there's something in the trunk that he has no expectation of privacy. So let's jump over to the Ninth Circuit case. This is a problem that happens regularly. The law is clear that internet service providers do not have to go hunting for things like images of child sexual exploitation. But if they find it, they have an obligation to report it to the National Center for Missing and Exploited Children. And they do that by sending a package electronically, giving a quick report, including the images, and information about what account it came from. So it'll give the username and an IP address. This particular case involved Google. And Google had, notwithstanding the fact they're not required to, Google has, as a lot of these service providers do scan things transiting their networks for images of child sexual exploitation. They do that using what's called a hash value. A hash value is a computer function that can take any computer object, a file, a picture, an entire hard drive, and convert it to a string of letters and numbers, but 30 to 40 letters and numbers long. And that hash value uniquely identifies that file, that hard drive, whatever it is. Uniquely to the extent that if you have a Word document and you change a semicolon to a comma, the hash value will be different. And I don't mean it changed one letter or one number. The entire thing looks different. You just look at it and go, no, they're not the same.
So is that artificial intelligence technically that's recognizing this obscene content? Is that an accurate description or not?
Yeah, I think so. Here's what's happening with a picture. If you change one pixel in the picture, the hash value will be different. Google had created a library of images that they had previously identified as looking like child sexual exploitation material. They did not keep the images. They did not keep any index of what the images were. They just had a file that had hash values. As things transit the network will look for attachments, in this case, an image. It creates a hash value of that image. It compares it to that library that they have. And if there's a hit, this is the same hash value we've seen before, it flags it. And so that's what they were doing. Go back to the dog sniff case. If all the hash value is going to tell us is this is contraband, then is it a search or not? So the argument might be, well, that wasn't a search. But if you flip the problem around, consider a computer forensic examiner conducting an exam of a computer in a fraud case. And he's authorized by the search warrant to look for evidence of fraud. So it'd be looking for documents, looking for lots of stuff that might be relevant to the fraud. He may do keyword searches through the hard drive to look for what might be important documents. He says, while I'm here, I've got this list of hash values of child sexual exploitation images that I can just run a search on and see if any are on the computer. Using the dog sniff cases as an argument, that's not a search because all it's determining if there's contraband or not. That doesn't feel right.
Right.
So that's kind of the background of the problem. So Google conducts the search for a hash value. Google then, without any human being looking at the picture, sends it to the National Center for Missing and Exploited Children, who assembles a little package getting in from, they do some background research. Okay, this IP address, who does it belong to? That requires getting some process against the internet service provider, Verizon, Comcast, one of those. They identify the person. They say, oh, this person's in Pennsylvania. Every state has a Internet Crimes Against Children task force. So they send it to the Internet Crimes Against Children task force, in this case, I think in California or New Mexico. I don't remember anymore, but they send it there, and the detective who gets it now opens the images and looks at them. And it's the first time a human being has laid eyes on the images. And the court holds that that exceeds the scope of the private search.
Right, because the critical fact there is that no Google employee had viewed the images before the law enforcement officer did, right?
Right. Now, the questions that come up in my mind are, suppose Google had actually kept a little document file that described generally what that picture showed. If you read the opinion, the officer sets forth in the search warrant a description of the image. He doesn't attach the image for the magistrate to see, but he describes what the picture shows. Suppose Google had, when they found that picture the first time, said this hash value shows this type of image. And they, even if they did it in a completely automated way, if they sent the file and the description of the image to the officer, I think the case might have come out differently.
Then you think the officer might be allowed to search it?
Yeah, maybe. I don't know. I mean, this is a good argument.
I see what you're getting at, like how unclear it is. And it makes me think, I want you to just sort of think about this is, obviously like this circuit split is happening in real time right now, and it's the year 2021. Do you think there's a maybe like prudential attitude that might be like sort of at play here? You kind of thinking like, well, you know what? Right now, Google's capable of having AI kind of recognize these images and do these things. In 10 years, think about what AI might be capable of
absolutely.
right? So I would think like, look, I'm not saying that this is the role of a judge is to think this way, but as a citizen, I would think like maybe the most prudential outcome for the case would be that we limit the amount of sort of observation that any sort of AI or artificial thing can have. You know what I mean? Because if we legitimize that, if we legitimize that now, and they only grow in their ability to observe these things, then I think it's going to be increasingly difficult to make the case that the government can exceed their search. You know what I mean?
It's interesting because you raised the question: is when a computer looks at something, is that a search? I mean, our concerns about privacy are that human beings can perceive. The illustration I've given in the past is take a wiretap and suppose that the government, instead of listening to the phone, plugs the wire in at one end, and old-fashioned technology, not digital technology, which uses voltage changes. So they then run the wire to a machine that converts the voltage changes to power and runs a toaster. I don't think we're concerned about that. We're concerned about the hearing of what's being said on the phone. As you're describing, as artificial intelligence gets better, and we can say that set of zeros and ones is this picture. Now, we already have that with a hash value. If Google had saved a copy of the picture and the Google employee had gotten the hash value, pulled up the picture and said, yep, that's child pornography, and then reported it, I think we'd be fine.
Yeah, then it would be much more. It would be
a private search. Exactly. That's why I say the next step is suppose Google had created kind of a summary of what's on that picture.
Right.
That I think might be okay, but I'm not sure. The reason I don't think this case is going to get to the Supreme Court is the government said we're not going to argue that it's contraband, and therefore there's no expectation of privacy in contraband. And I think if the Supreme Court is going to take the case, they're going to want that issue to be front and center. Now, the government, as the opinion notes, this search was done in 2015, and some cases came down around 2016 challenging this. And the practice now is largely that the agent, if no human being has looked at the picture, the agent gets a search warrant to look at the picture first. So this may not come up again.
Right. And another thing I wanted to mention, which I just thought was interesting, was, you described in very good detail the whole hash value thing. It's interesting because if you gave us a hypothetical, it's like, I guess I'm offering my own hypothetical here, just kind of in the background, which we're making the assumption that the hash value obviously is the technology behind it operates with certainty. You know what I mean? It only produces these determinate certain things. There are no errors in it. There are no internal errors in the system that would cause like misleading.
It's probably better than DNA with human beings.
Exactly. Right. So that's what I find interesting is maybe we would be looking at these things differently if we knew that there was even a 0.1% of error on some of these AI detection machines, because then it would be like, oh, well, if the AI is referring somebody, it could be wrong. So if the AI is wrong, then maybe we shouldn't allow a human being to go search after the AI did. You know what I mean? Mm-hmm. I just think that's interesting because it kind of, like, we're kind of making the implicit assumption the whole time that the AI is always right, and that
we can't do that.
Yeah. So
it's the old. It was on the internet. It must be true.
Right.
A computer generated it. Must be right.
Right. Exactly. So, is there anything else you'd like to say about the circuit split?
I think it really illustrates how, when we move from the physical world, opening a suitcase or a package, we can kind of figure out what the private search was. When we start moving into the digital world, we get all these gradations that are really hard to figure out. And the court kind of recognizes it in its opinion. At one point, it says something like, first there's this maxim of digital is different, which I think is right. I mean, I joke that libertarians and defense lawyers think that means the government always loses. I I think it's a tautology. And the court recognizes with the opening sentence where they quote the US Supreme Court that's saying, when confronting new concerns wrought by digital technology, this court, meaning the Supreme Court, has been careful not to uncritically extend existing precedents. You need to look at what's going on here. We look for analogies to the physical world with computers. They don't always fit. And this is a good example of something this is not a human being looking at it, which you had with a suitcase or the FedEx package.
That's why it's such an interesting case, because it's kind of at the cutting edge of technology, right? And it's kind of exacerbating the vagueness of the doctrine involving privacy, right?
Right.
Now that we've discussed all that, could we talk a little bit about what, you majored in mathematics here, which is obviously very different from what you ended up pursuing in your career.
It's very different what math is today.
Exactly, yeah. So what were you thinking as a senior, and how did you see your career developing from that?
Sure. I was a math major. I grew up in the post-Sputnik era, 1957 on, with a huge emphasis on science and math. I think we're beginning to see some push towards STEM again today, but my generation was really pushed toward that. So I had a mind that worked well mathematically. It's probably why when I came to the end of my career and started doing computer crime, I was comfortable with it. It wasn't that I was a computer specialist, but my brain worked the way that understood something about computers. So I was a math major. I'm in my senior year in the fall, and I'm taking a course in topology, and the professor puts something up on the board, and I look at it and go, I understand what he's doing, but I would have looked at that problem for 1,000 years and never thought about doing it that way. And it kind of dawned on me that to go on in mathematics, to go to graduate school, which had been my plan, you needed both a touch of genius and imagination. I'm smart, I'm a hard worker, but I'm a plodder. And my SAT scores were below the class average, but I graduated cum laude. So I worked hard.
Exactly.
So I'm sitting there and going, I don't know what to do. And I kind of mulled it over. And one day, and it was after Thanksgiving, I know that because I'd already been home for Thanksgiving and talked to my father about it and still didn't have solutions. I ran into the director of admissions, Charles Debler, who I'd known. He became a friend. And he said, what are you doing next year? And I said, I don't really know. Here's my problem. And he looked at me and said, law school is the ideal place for the senior who doesn't know what he wants to do next year. And that got me thinking about law school. Now, my father had been a lawyer before I was born. He had enlisted in the Army in World War II. And when he came out, I was already born. He wasn't about to start up a law practice, so he never practiced again. So law was kind of in the background. So I went to law school. I got bitten by the criminal law bug, I think in part because the man who taught criminal law my first year was a phenomenal teacher. And I had some pretty poor teachers first year. And I just got interested in it. When I graduated, I clerked for a state court judge briefly, and then went to the public defender's office in Philadelphia and worked there for over 3 years. Went from there to the district attorney's office, joined two friends in the DA's office in private practice for 4 years, ended up being a nonprofit organization. Not that we planned it that way, but we just weren't making money. Applied to the US Attorney's Office, got a job there. I left there twice to go into private practice, realized I just like being a prosecutor. And so that's what I ended up doing.
Right.
So, I kind of fell into law school, and I kind of bounced around in the practice of law. I moved around a number of times between 1970 and 1990 when I returned to the US Attorney's Office, and I stayed there till I retired in 2019.
Were you confident at the outset of going into law school that you were going to be successful?
No, and I don't think anybody is. Law school is difficult. I had two problems.
But you knew you were a hard worker, so I was thinking.
I knew I was a hard worker, but I came in with mathematical reasoning, and law is a logical discipline. But words are important in law, and I was used to pure reasoning using symbolic logic. And as problems get nuanced, the law probably needs to change. And law school professors kind of drive you in their questioning. And if you're holding to a principle because you think, well, that's the principle that applies, eventually you end up with a silly result. And it takes a while to understand that. The other is, it's just law school in general is confusing. And the first year is awful. I warn everybody in advance. It was in the men's room on a stall was written when I was there, this is the only place in law school where I'm really sure of what I'm doing. And that kind of summed up my feeling about law school first year.
Hilarious.
I began to get it, and I became pretty confident as I went along. But if you go to law school and you feel yourself struggling at first, you're not alone.
Right. So, I mean, it's something that obviously, it's not for the faint-hearted, right? I mean, no matter what, even for the brightest kids that come out of even places like Brown, you're gonna have to really work hard during those 3 years, right?
Yeah.
Is there any advice you might have for upperclassmen that are considering taking time off in between Brown and law school? Would you advise either for or against that?
If you can do it, I think it would be great. I can tell you that from teaching since 2005 as an adjunct at Penn. The people who've been out for a couple of years, you get a couple of more years maturity. You're pretty mature at 22, but you're even more mature at 24, 25. If you look at the studies about the development of the adolescent brain, it doesn't really hit full maturity.
I think it stops at 25. So it's your point.
Yeah, somewhere around there. The other thing is you just have a practical experience. Your experience is not just academic. And so you just look at the world a little bit differently when you've had to wrestle with those things and begin to realize that things aren't always black and white the way they are in college, that they get sort of gray. So if you can do it, I'd advise it. If you can get a job that's somehow related to law, so you can see what lawyers do, you may watch what they do and go, this is not for me.
Right.
Better to know that before you've spent all the money
right.
and time going to law school.
Right. And that leads me to, there's this idea that post-grad institutions, whether it's law school, master's degrees, things like that, there's a lot of credentialism in our country, obviously, right? So there's a whole camp of people that think that, law school, you really don't learn anything in particular that's useful for the rest of your career. It's really more so than anything just, padding your resume, getting that signaling power so that you can eventually get the clerkship or get the summer associate at a private law firm, right? Off that, my question is, did you feel that you truly benefited intellectually from law school, or was that merely just going through the procedure of credentialing yourself?
No, there's a definite benefit to going to law school. You're right. If you're not going to practice law, you probably don't learn much that's practical and useful. Again, if you're practicing law, there's a minimum, there's only a certain amount that you're going to learn in law school. Most of it you learn while practicing. But you learn a way of approaching problems, a way of breaking things down and looking at their parts. I always remember my father, when I was about to go to law school, he stopped practicing law in 1942. I went to law school in fall of 1966. He worked as a plant manager for a wire factory and ran the place. He said, I still use that way of analyzing problems. I break the problems down into its constituent parts and figure out how I solve each one.
So my father's a lawyer, and he said the same thing about how it teaches you a way to think about problems that is, it changed his perspective, I think,
yeah,
for the rest of his life. And does that suggest that your view on that is that, even if you don't go on to practicing law or to really committing to practicing law, do you think it's sort of worth it anyways to go to law school just for the pure logical reasoning, critical thinking skills that become of it? Because, in perspective, relative to some other, like let's say medical school, for example, yeah, law school is only 3 years. So it's really not like, sure, of course, it's a significant commitment. So don't get me wrong, but it's not med school, So right, there's a legitimate possibility that people can fit that in, even if they're not even planning
right,
to be practicing.
And the MBA is only 2 years, and it'll probably make you more money. So. I wouldn't go to law school with the idea I'm never practicing law. I did have one classmate who did that. It was in business, and he wanted the legal background. But I wouldn't recommend doing that just for, you're thinking to get sharper without spending all that money in 3 years doing that. But if you end up graduating law school and then deciding this isn't for me, I don't think it's been a total waste.
I see what you mean. I've also heard that a popular criticism of law school is that it's more of an antiquated teaching approach that more so favors people that are looking for clerkships rather than people that are actually going to practice privately. Would you agree with that?
Yeah, Penn is kind of unusual that way. The basic academic structure is that we train people to be appellate court judges, not to be practicing lawyers. There's been over the last 15, 20 years, there's been a lot of ferment in the law, particularly in legal education, about that. Efforts to, why don't we cut law school from 3 years to 2 years? Well, that cuts the amount of tuition coming into law school. So that's probably a non-starter. But Penn has really beefed up the adjunct program. And they have courses that involve representing clients in domestic relations court, and representing children in abuse courts, negotiating business deals and helping to prepare documents. So there's at least, and I'm not sure what other law schools are doing, but there's a lot more practical training that at least I see at Penn.
Right. So
it's not part of the regular curriculum, but it teaches law students what it means to practice law.
Right. Because of course there are those extracurricular clinics and those sorts of things that help with that too.
Some of these many of these are credit courses. So they're not in addition to courses you're taking, they are substitute.
I see. Cool. So that leads us to our final question, which is there any recommendation you have for either a book or a piece of art that you'd recommend to pre-laws here at Brown?
A good number of people in my generation were inspired by the book or the film To Kill a Mockingbird. It's a great story. Everybody wants to be Atticus Finch at the end. When my wife argues with me about how can defense lawyers represent these people, I always say, you remember Atticus Finch? When the judge asked him to represent Tom was a black man in the 1920s or 30s charged with raping a white woman in Alabama. And Atticus Finch doesn't ask, is he innocent? He tells the judge, I'll take the case.
Right.
Think about the pressures that are on him.
Right.
That's inspiring.
Contextually, it's a completely different ballgame.
Yeah. So, there's a lawyer in the film Bridge of Spies with Tom Hanks, who represents a spy. And people are throwing bricks through his window because he's representing a Russian spy. Movie that hit me hard, and I was at Brown when it came out, was Judgment at Nuremberg. And it hit me for a different reason, which was in the course of the trial, the German defense lawyer representing a judge who's charged in these trials reads an excerpt from a United States Supreme Court opinion that basically supports eugenics and forced sterilization of mentally retarded people. And it was a complete shock to me that this had happened in the United States. Books to read, if you're interested in the practice of law, Scott Turow probably gives the best picture of what life of a lawyer who goes to court is. I'd skip Pleading Guilty, which is effort to write a Mike Hammer type story, or Ordinary Heroes, which is a great book, which is not about courtroom lawyers. But the rest of Turow really gets what practicing law is like. Now, he's a trial lawyer. So I don't know of any books that will, here's what a lawyer involved in business practice or securities practice.
Right. It sounds like it wraps it up. Obviously, thanks so much for joining us. I hope maybe in a year or so, we'll check in with you again, because we're always interested to hear any of your opinions on any of this. And it's really been a pleasure talking to you. Really appreciate it.
Thank you very much. I really enjoyed it.